table that we provided for you at the back, both at regional and international level. So we have international and United Nations treaties that we have ratified and their protocols. It numbered all the way down to 36 of them. So we listed all their names and the dates that Gambia have ratified them since independence. Then we have regional human rights treaties that we have ratified. That, when we say regional, we mean at AU level, that we have also ratified since independence. They are also listed, there are about 12 of them. And we also indicated the UN treaties that we are yet to ratify. And we've given you a list of them, about 4 of them. That is the optional protocol on the Convention Against Torture. So we have ratified the treaty on torture, but there's an optional protocol for it, which states can decide whether you want to ratify them or not. So the optional protocol on torture at the UN level, we have not yet ratified that. We have not also ratified the optional protocol to the International Covenant on Economic, Social and Cultural Rights, and also the optional protocol on the Convention on Elimination of All Forms of Discrimination Against Women. And we also have the optional protocol to the Convention on the Rights of the Child on Communication Procedure. Some of these protocols, basically, to summarize, they usually give their complaint procedures. They are additional instruments that are added to the treaty, usually to create complaint procedures or to create mechanisms where people who are aggrieved, they want to use the treaty bodies to complain and file complaints against states and things like that. And the other UN treaties that we have also not ratified at the moment is the Convention Against Discrimination in Education, Employment Policy Convention, and Convention concerning occupational safety and health and the work environment. Then Slavery Convention, we are yet to ratify that as well. Protocol amending the Slavery Convention on the abolition of slavery, and also finally the Convention for the suppression of the trafficking in person and the exploitation of the prostitution of others. Then at AU level, there are 2 protocols that we are regarding the TRRC. Can I go ahead or I can stop at this point? Okay. Regarding the TRRC, of course, you will aware, let me just read this verbatim, it's not long, and then we can edit it and provide you with copies. The TRRC, of course, recommended the banning of a number of individuals. So I was looking at suspension of adversely mentioned persons after the publication of the white paper. It recommended the banning of a number of individuals from public service for varying length of time due to their participation in human rights abuses and violations. Upon the release of the white paper, we have now written to various institutions, mainly the armed forces, the immigrations, the police, and other places where these named individuals are working. Because we are of the legal view that their cases need to be looked at on case-by-case basis to determine those that should be outrightly dismissed or compulsorily retired or terminated. Because of that, we are not yet in a position. We have to work closely with the Public Service Commission. So what we did now is to just notify the institutions that they work in and ask them to be placed on leave or suspension. So those letters have been done and distributed. There are some situations where we receive some new evidence that can potentially exculpate some people that have been mentioned. So we refer to them for further investigation. 2 among them is the case of the former Minister of Interior, Yankuba Sonko, and Superintendent Alman Manga of the Gambia Police Force. After the TRRC completed their work, we have seen some evidence that we believe, if those evidence are viable, it has the potential of freeing them from the allegations. But we don't take that decision for ourselves, so we wrote to their respective institutions to set up a transparent process with National Human Rights Commission monitoring the process, and they set up cross-cutting. These 2 people are not recommended for any prosecution. It's still the same banning for Almami, in fact, it's not banning. It's just they ask that the police should reprimand him. But because his name and reputation is on the line, we owe him that fairness, that with the new evidence that came to light, let independent bodies look at the evidence. If he is not found wanting, I don't think he should be adversely mentioned in the report. So those two letters also have been dispatched, both to the Ministry of Interior and the police force. Now, with regard to implementation strategy, the white paper more or less is just a statement of intent. The TRRC recommended something and government said yes or no. Now, the next phase is to come up with a tangible implementation strategy that will translate the white paper into a program. That is, will have measurable activities, costed, and with deliverables that somebody can monitor. So we are working on securing a consultancy to start working on that in earnest. On key milestones, specifically still on implementation, is the setting up of a special criminal or crimes division. The government have decided that due to the complex nature of some of the offenses that have been named in the TRRC report, quite a number of which were not even criminalized in the Gambia at the time they were committed, or even up to date. They are not crimes in our statute books. So therefore, we may not even have capacity to prosecute them because our trained lawyers have never prosecuted torture, as simple as that offense. Enforced disappearances, these are not offenses in the Gambia. And they have been found to have been committed by individuals during the previous regime. So we thought it prudent to set up a special prosecution division. And in that division, we will hire experienced people who have knowledge and experience in how to prosecute these offenses. And the setting up of that division, we are in consultation with our development partners, because one of the challenges that probably I'll highlight later in resource mobilization is we are mindful that the TRRC white paper has been published around mid-year. And at that time, government budgets were casted already. So we do not have resources available for implementation to commence this year. So any implementation activity we want to take up now, for example, we want to set up a special prosecution division, this is supposed to be a government responsibility, but we do not have ready budget for that. So we are talking with development partners, hoping that at least we can have a stopgap support for now to initiate the setting up of this division. Then we have the victims reparation bill. The TRRC's mandate included reparation, and it's even captured in the name of the TRRC. Government provided them $50 million while they were still doing their work. So they used these $50 million to pay some interim reparation. Now that TRRC is over and reparation is an ongoing thing, it's far from complete, we deemed it necessary to come up with a successor institution that will continue to be responsible of reparation. So we've conceived a bill, and we have had 3 days consultations with civil society on the bill. And last week, the bill, we have got some of our staff and some members of the civil society that went on a nationwide consultation to capture views and opinions as to the form and content of the bill. So we're now going to capture those comments that we have got from around the country and finalize the draft and then subject it to validation before it is introduced to the National Assembly. That will create a body with a clear mandate to continue to receive and administer funds on behalf of victims. Then on the resource mobilization generally, we are already in discussion with development partners, and we have seen a lot of goodwill in the development community, our partners. So, like I said, we have to translate the white paper into programmable activities, which are fully costed, because you don't go to ask people for help when you don't even know how much you need. So we are working on developing that program, costed, and then raise the necessary resources. But the feedback we got so far from development partners, there is an indication that they will support this country along this line. Now, some of the challenges for the post-TRRC implementation of the white paper, the topmost is immediate availability of resources, like I hinted earlier. Ideally, if resources were available, some of the things would not wait, we would have started now. But the resources are not readily available as of now. So mobilizing resources is the immediate challenge at the moment. If you expand that, we could say in the long term too, availability of support in the long term too, we foresee that to be a challenge because the scope of activities that needs to be implemented are very far-reaching and they can be very costly because they've recommended, say, institutional reforms. For example, the need for a new prisons. These things are not cheap. They are going to be very expensive. So they require resources. They require a lot of resources. So in the short term, it's a challenge. There is no immediate available resources available in the short term. And we foresee this to continue to be a long-term challenge too, depending on how much support we are going to be able to harness from our development partners. Capacity too continues to be a challenge. Capacity both in terms of manpower and probably, but more manpower. Like I hinted earlier, we do not have trained people ready. For example, if you look at just, if you look at the accountability part of it, just let's say prosecution part of it, we do not have the manpower resources readily available, both in the ministry and in the judiciary right now, to deal with some of these offenses. So capacity remains a challenge, especially human capacity. At the moment, my ministry is overstretched in terms of manpower with our core mandate already. And the responsibilities that have been posed by the TRRC report is an additional responsibility. So we are already struggling with our core mandate of providing the necessary legal services to the entire government machinery. So with this added mandate, so the manpower is a big problem for the ministry. So hopefully, we hope to close that gap by hiring more people. And hiring here requires more resources, but it also requires us working closely with the competent government authority for personnel, that is the PMO and the Public Service Commission. Another challenge would be the legislative reform component of it. There are a lot of planned or recommended activities that will require change in legislation, or in some cases, introduction of completely new legislations. So that remains a challenge because legislation process, Honorable Chair, with your experience for the past 5 years, you know it's a challenge, it's not easy. So it's a whole process, even at our end, at the executive end, to work on a bill and complete it. If you introduce it in the National Assembly also, that's another level also, and there is a whole long process there, and a tedious process. However, those that require speedy legislation, we expect to make use of the tools available to us at the level of the executive. If requiring using emergency procedures, we will, but that's our level. But even before you invoke those ones, you have to get the basics. You need to get people, stakeholders in an area of legislation to come together and come up with an acceptable draft before you even can invoke those procedures. But legislative reform is also one key challenge in this area. But we are prepared to embark on the assignment. So basically, in a synopsis, these are some of the key updates and challenges for the post-TRRC as well. Thank you very much, Chair.
Very much for this brief explanation of the recommendations, the conventions, challenges you have taken us through. Before I allow my honorable members to ask questions for clarity, I want to seize the opportunity to ask my first question.
Thank you.
And that would be the fact that the TRRC was put in place by this government. Were they not expecting that the outcome would be like resources would be needed, reforms would be needed? Why is it taking them by surprise? Because it seems government is not ready for the full implementation of the recommendations because of the challenges like resources you mentioned, both manpower and finance. So I would have thought government should have think ahead to say that this TRRC will come with recommendations and then we need to have our plan B in place. Is that not the case? If not, why?
Well, we anticipated some that we could legitimately expect. There are some there was no way of us knowing because the TRRC was independent, so we do not know what they were going to recommend. So you cannot prepare for the unknown. The ones that we expected and are certain, which is things like reparation, I have gone public to say government have put over 100 million, I think 150 million in the budget, which was approved by this parliament in anticipation of reparation. Right? But for prosecution and other things, it is very complex. You do not know how it's going to come out, how the recommendations were going to come out. So to be honest with you, we were clear from the policy point of view, but in terms of program point of view, it was difficult to prepare for it. But policy-wise, we were clear, we knew we will have to prosecute, but how are you going to prosecute? What are the costs? What are the details and programs? Which are still subject to a lot of things. For legislative reform component of it, you couldn't know which law they were going to recommend to change. So you have to wait for the report to come, and then you make up your mind. So some we anticipated, we were ahead of time at policy level, but operational level in terms of cost and implementation, we have to wait for it to come first.
Okay.
Yeah.
Honorable members, yes.
Yeah, thank you.
Let's start the first one.
Thank you very much. Thank you very much, the Honorable Minister and the Solicitor General for coming. It's because of your respect for the law, that's why we are here. And I always tell people, I commend this government for its human rights achievement. I always say that the only thing that this government falls short is on check and reckless corruption that is everywhere. But as far as human rights is concerned, I always give them a positive report card. Now, you talk about some of the international conventions or treaties that are ratified but not yet domesticated. For me, like experts going outside this country, from your ministry going to ratify these conventions and treaties all over the world, in paying per diems and air tickets, only for it to come here and not been domesticated. It means that at one point resources have been invested and hence, even it is not domesticated, you and I know it's never going to be done in this country. So I'll urge your ministry to get speedy with domesticating those other human rights conventions that you ratified around the globe, and they are not domesticated to become laws in our country. Now, you also talk about the TRRC recommendation for certain people, and your ministry has written to them already to implement such recommendations. So I don't know whether those recommended to be banned from public service are still receiving salaries or they are without salaries. Since your ministry has already written to them whether they are receiving salaries or they are receiving house salaries for that matter. Now, you also talk about new evidences emerged for two people, Mr. Alimame Manga and former Inspector General of Police. How were these evidences raised? I want to see this as an isolated incident, follow the same procedure as for the former Inspector General of Police and that of Mr. Almami Manga. When new evidence emerge for others as well who are implicated, whether you guys will do so. So my recommendation will be if you guys can let the courts to deal with those evidences that at your level you deal with such evidences and for a potential acquittal, I will urge your ministry to let that for the courts to decide. The courts to decide on those new evidences that at your level, at the executive level. You also talk about independent bodies, hire independent bodies to to look at those cases, these two cases, those independent this thing, whether you call them consultants or to deal with these two cases. For me, that's going to be another waste of store resources. I'm sure your department is very resourceful. The case of the former NIA, Mr. Usman. So you never talk about that. Actually, I'm just trying to raise that because the public there is too much public outcry on that case. So I don't know why the executive will acquit him of all TRRC recommendations and still working when in the full fledged of evidence. We've seen that under his custody and so many evidences were tampered at NI headquarters. So you have given your speech, and I didn't hear you mention anything about him. And there is too much public outcry that he has done quite a lot of terrible things under his custody at the NIA. Let's not talk about reconciliation. When we want true and genuine reconciliation, it has to come from the president. We've seen lately the president visiting conspirators of crimes and leaving the victims. For me, if there is going to be any genuine, any genuine reconciliation in this country, it has to start from the president. Let the president visit the victims, show solidarity with the victims, but not only to go to conspirators for any political gain. So let the president start the reconciliation process. If he cannot visit every family, but the victim center is there for him to go and show solidarity to the victims that I feel your pain, I feel everything about you, so that we can start a genuine national reconciliation process. Thank you very much.
Thank you. What do? We allow him to respond.
There are many. So
Yeah, it's better you respond and then we take the next question.
You took a position regarding domestication, but I can tell you it's more complex than that. Gambia is not in isolation. International treaties you sign them, but you don't guarantee that every treaty that you sign you will domesticate. There are some treaties, in fact, from the executive point of view, we might take a policy position that we will never domesticate them or conventional. So, because it is for Gambia to decide what it wants to reform part of its domestic legislation. So it doesn't mean any international law that you sign, you have to translate it into your local law. So, and also it is a process. So to call that as a waste of resources to go and sign an international law and not to domesticate it, I think probably you need a little bit of a level, with all due respect. We probably, maybe over time, we will create some enlightenment. That's not the way how we look at it. So non-domestication of international law is not an offense. It's normal. You can sign an international treaty. In fact, some countries will sign and enter reservations that we are reserving. We're only signing it because you are part of the international community. So you can choose to ratify and respect certain provisions. We don't want it to be part of your domestic legislation. Those that you consider expedient to be part of your domestic legislations, you domesticate. But we, like I said in my report earlier, those that we deem necessary to domesticate, we are in progress. But it's also a process, and we are domesticating as many as we possibly think is expedient for us to domesticate. Now, regarding the banned people, whether they are on salaries or not, I'm not too sure, but this is a complex process. That's what I said. We asked them to be suspended. And then we have to look at their case one by one. This is a case-by-case situation. Because it's employment issues. You don't want to take a step where tomorrow they will now sue government and claim certain things. So we're still studying their situation. And one thing we need to understand, the recommendation for ban that we received from TRRC is not law. And the acceptance of government is not also law. So we want to make sure that what we are going to do after having accepted the recommendation is done following due process. So whether they are currently receiving salaries or not, I don't know. But we have recommended at least the minimum they should not be at work. Let them stay away while we review their individual files and take a proper legal position as to what should happen to them. So regarding the two individuals I mentioned about we received new evidence, whether it's not discriminatory, no. We received this from these two people immediately after we received the TRRC recommendation. If we receive such thing from anybody that we think your case need to be looked at, we will definitely refer it to be reviewed. We are not averse to anybody who believes you've got good evidence that shows either the TRRC there may have been a miscarriage of justice or not. Remember, these people probably couldn't go to court because they are not recommended for prosecution. We are only doing this for people who are only recommended to be banned. So they have nothing to go to court for. All right? Some of them are only recommended to be reprimanded. So all that they need is for their name to be cleared. If they believe that what they did, they are alleged to have done, they have not done it. So we just accord them an opportunity. So if we know anybody, if you are recommended for prosecution, government is not going to do anything about that. That one you have to go to court and clear yourself. So we are not exonerating anybody who has been recommended for prosecution. Those ones are for court. But this is like somebody should be banned or somebody should be warned. As simple as warning, some people think the fact that I let it go, if I am warned, it means I did it. And if you believe you did not do what they said you should be warned for, and you got good evidence to show that you did not do it, we accord you another procedure, which we are not going to be interfering in. National Human Rights Commission will participate, and any other independent body can observe it, and then they can look at it. For example, if they say you were at point A when a particular offense happened, you came out with evidence to say I was never there. All right? So it's for somebody to look at. Is it true? If you say I was not in the country, for example, when they say this happened, but notwithstanding somebody mistakenly either believe or whatever that you were there, we are not giving anybody any VIP treatment. We said take your evidence to people who are credible. Let them look at it. If they confirm that it was true, you were not there, how could you have possibly done something when you were not even present? So those are the kind of simple things we're just trying to clear. And we're doing it through due process to clean the records. The issue of consultant, I don't know where you got that on record. I never mentioned consultant, so this is not going to be at any cost to government. It's going to be existing institutions that will look at it. The police is there, the National Human Rights Commission is there, and other independent bodies that they can invite to come and sit. It's not going to be a cost to government. So I never mentioned that it was going to be a form of consultancy. So it will be looked at by existing institutions under their mandate. But we don't want one single institution to do it, because the outcome should be credible. So it should be done by a cross-section of institutions coming together. So you have 2, 3, 4 credible institutions. We believe, for example, if the police want to compromise, maybe National Human Rights Commission will not accept to compromise. If National Human Rights want to compromise, maybe Interior will not compromise, or Justice, representative of Justice will not compromise. So when you broaden it as a task force, they look at it. If they agree that there is something that one can rely on, we will accept and consider their report. So that's the approach. We did not recommend any cost to be incurred in this review process. Now, Usman Sow is already done and dusted in the white paper. So, because I'm not required to mention or look at any particular person, I brought in Manga and Sonko because these are two people that we have referred for action. Sow's issue is concluded in the white paper, and the government have given it justification in the white paper, and that's the position of government, that the TRRC recommendation falls outside of their mandate. There is no way government can accept a recommendation that is outside of mandate. They were meant to look at between July 1994 to January 2017. By January 2017, Usman was not the DG of NIA. Whatever he is accused of having done is done outside of the mandate of the TRRC. So the recommendation falls outside of the borders, parameters where they could make recommendation. So they were not required to look at any activity, rightly or wrongly, that happened outside of January 2017. So on that basis, it was rejected. What government is going to do with whatever Usman does, that's for government. But we need to separate things, that it cannot properly be formed part of the recommendation of the TRRC. So,
Honorable Minister, well, with all due respect, the evidence that the former that Usman show tempered with were within the mandate of the TRRC. I mean the time frame.
what do you mean?
Because it's not the evidence that he tampered with. That's within the mandate of the TRRC.
No.
It happens before.
You reprimand somebody for an action. You reprimand somebody for his conduct. The question is, when did the conduct allegedly happen? The conduct of destroying evidence, or the alleged destruction of evidence. When did it happen?
I think, well, no, well, look, you don't.
Because the TRRC is set up
okay
to
with
look
that.
at the conduct of people
Okay.
from period A to period
All
B.
right, he's okay with that. Can you
Yeah, so-
Can you proceed?
All right, that's our position. So, the president, what the president does and does not do, I don't work at the office of the president. I cannot speak for the president. Whether he should choose.
You can advise the president. You are the chief legal advisor of the government.
Yeah, but is that a legal issue?
Yeah.
Is that a
For me,
legal
if you
to
actually-
choose to go to? Of course, I'm in charge of the transitional justice process. We have our plans regarding national reconciliation. We appreciate the importance of national reconciliation. And we have our plans, which we will make public very soon. Yes.
Right, good. Next question. I will sign up.
No, I'm done.
Oh, you're done. And I will. Okay. Kante.
Thank you very much, Mr. Chair. Thank you very much, Honorable Minister, Solicitor General, and the colleagues. My question is, the Honorable Minister did made mention of setting up a prosecution division to deal with the TRRC report for possible prosecution. Having looked at that, the evidence is very key in securing conviction in any prosecution. So now, most of the TRRC reports of alleged torture did happen at the premises of the National Intelligence Office. And we were told, or we did know from the TRRC report, that most of those evidence, material evidence, were not available or been tampered with. So how did the Honorable Minister of Justice is going to go about with that issue?
The allegation of evidence tampering at the NIA.
Very, because for this prosecution for the prosecution office that you intend to establish to work effectively, they need an evidence base. And we were told that the report of the TRRC did reveal that most of the evidence, material, yes,
Oh,
regarding torture,
all right.
were being tampered at the National Intelligence Service. So, how are your office going to deal with those evidence issues?
Well, for now, at this stage, the Special Prosecution Division that will be set up will have an investigation department. So they will make assessment of the available evidence, and they will advise government if they get to that point that they needed certain evidence in the NIA and this piece of evidence were destroyed. And they would advise government what to do at that stage.
Okay, the second question would be on the reparation of victims. You did mention that the victims, some of them have already started receiving the reparation, interim reparation. So, which we are going to commend the government stance on that. So we will say it, Honorable Minister, being the one responsible for this transitional justice, to facilitate this transitional justice, will urge your ministry to fast track some of these reparations to the victims, because as far too long, these victims have undergone series of pain. They have now established, according to TRRC report. Most of these victims, some of them have suffered since 1994 to date. They are crying, Some of them lost their loved ones. Some of them, are denied of their, life and livelihood support from their loved ones. So we urge the Honorable Minister to come up with a policy to fast track this reparation, benefit to the victims. Thank you, sir.
Thank you very much. On this, we are in full agreement. The issue of victims is central to whatever we are doing. In fact, we've thrown the challenge to the victims to work with us to see whether in the interim, before the victims bill is enacted, between us, that is the victims and government, if we can agree on any kind of mechanism, independent and trusted mechanism, that can do the work of what we intend to create, the successor institution. The problem with reparation, it deals with resources. And government doesn't want to have a hand in the way these resources are administered because it can be complicated. Even the interim payments, the TRRC did, some victims are not already happy with it, they are complaining. That is either not fairly done or it's not adequate. So for us, it's a hands-off approach. But we want to have an arrangement that the victims can trust, but that will also be in line with the way public funds are managed. Once we get such an institution up and running, we will definitely not lack at least the seed money that we can put there to start with. And because it's an ongoing process, this will form continuously. It will continue to form part of our national budget. And whatever our development partners have, they want to chip into that kind of fund, they will put it there. But the moment now is assuming government is ready to even pay another 50 million, another 100 million. To who are you going to give it? Who is going to administer it? This remains the challenge. This is what we are working with them. So in the meantime, the only option on the table is to expedite the enactment of the victims bill. But in the meantime, if we are open to suggestion, if we can have a kind of arrangement that is government can trust, but the victims too can trust, we will knock at the door of government, Ministry of Finance, and say, at least give us 50 or 100 or whatever amount is there. Let something be ongoing. But overall, I can assure you we are very sensitive to the plight of victims, and their issue is central to whatever we are doing.
Yes, Honorable.
Thank you, Chair, for giving me the platform, and Vice Chair and fellow colleagues. I greet you all. Honorable Minister and Solicitor General, I greet you all. And colleague present here too. My question is not a long question. I think Truth, Reconciliation and Reparation Commission, that is the TRRC, right? I think whatever we should center on as a nation, my belief, is the name of the TRRC. The name implies truth, the truth have already prevailed, according to the masses. Reconciliation, we should work on reconciliation. Reparation, and also work on reparation. Now, if we wanted another setup, we could have highlighted it and prosecution, you understand? Then we could have used this format and said truth, reconciliation, reparation, and prosecution commission.
Okay.
But that is never the case. You understand? So now we want to bring in another thing. How will prosecution help this nation? You understand? As a nation, this is the line in which we should be thinking. As a ministry, per se, do not try to please anybody, and you can't please the nation. But then do what you can to the best of your ability in reconciling the people and in the reparation too. You center your studies and everything and effort in this. Because everything that a nation is doing is towards the interest of the people. Now, for how long will we continue to persecute our people? You understand? So this is an important point that you should look into and do not be influenced by anybody. Act according to the laws of the land with your own claimed concept in the interest of the nation. That is the only thing I have to say. Thank you.
Thank you very much. Thank
Was
you.
that a comment or a question?
I saw it.
Whatever it is.
Honorable Minister, you cannot comment.
I'm just asking the minister.
It's a contribution.
It's a contribution.
Well, I can respond to you.
Okay, go ahead.
I think I must say one thing. You are not alone in your thinking in the Gambia. There are people who believe that we should not even prosecute anybody. We should reconcile and move on. So I can tell you are not alone. But however, the fact that prosecution is not mentioned in the name of the TRRC doesn't mean that if you go into the text of the act of the TRRC, you will see that prosecution was contemplated. And in fact, it was said clearly that those who bear the greatest responsibility of the violations, after the truth is known, have to be held accountable. So the prosecution part of it is just the accountability bit. Now that we know the truth, we know who did what. I mean, people like you would say, okay, why don't we reconcile and move on? Others are saying, no. Those who did wrong should also equally be accountable first before we reconcile. So that is the kind of debate that is in the population. But for us as a government, we believe crimes were committed. And that has been the law in this country ever since. When crimes are committed, people who commit crimes should pay for their crimes. Right? That is the government policy position number 9. What the population decides, that's democracy. Population can continue to debate that. Of course, I know population influences government policy, but as of now, the government policy is we are set to know the truth. And having known the truth, we are set to reconcile. And in that process of reconciliation, we are also set to adequately compensate those who suffer, but also hold those who made them suffer accountable. So these are the whole length of the transitional justice program. So from your submission, it's like, oh no, holding people accountable is something else we can forego with.
If it's going to cost us resources, you understand? And it's going to cost us human beings.
Justice have always cost us resources. The fact that a police officer will go and arrest somebody having assaulted you, even a mere slap, you go to police station. The police embark on incurring costs by taking a vehicle to go and arrest that guy. They are burning fuel. When they arrest him, they brought him to the station. If he sleeps there, they give him feed, they give him food. So justice is never free. We have always incurred costs for justice. But at the end of the day, is cost-benefit analysis. Is it a cost that is worth spending for the interest of the people? That is just what we do at our level. But the current position is, in as much as we value reconciliation and we value that those who suffered should adequately be compensated as a separation, we equally believe that those who have made people suffer wrongly will have to be accountable for their action, just like you and I, if we have done it, we will be held accountable.
Understood.
Thank you.
Another colleagues, any question? Deputy Chair, no question. Honorable Deputy Manager, Majority Leader, no question. On the AOB, anything on the AOB? I start from the Deputy Majority.
Blank check.
So because this question is very clear. On the AOB, I don't have anything to add.
Okay.
I address all the concerns.
Honorable Minister, you have a problem with human rights.
I have.
On the AOB, anything on the AOB?
It's okay.
We can
AOB, Honorable Minister of Justice,
Yes, Honorable.
I want to know, I did understand that the draft constitution was a government-sponsored bill that has made its way through the National Assembly and been, for some reason, rejected by the fifth legislation. I want to know, and we are aware that there was negotiation going on as to whether it should come back for second look at.
Okay. Yes, so
Now that the fifth legislation has gone and the sixth legislation is in place, we want to know from the Honorable Minister of Justice, what is the position of your ministry and government regarding the draft constitution? Whether we also have the opportunity to have it before us, and also this has, it's supposed to be done, either to be to vote it to pass through as a progressive document some of us believe, or it is also going to be rejected. But the opposition, as the Minister of Justice, are you ready to make that document available before the sixth legislation?
yes, answer is yes. The government is committed to reintroducing the draft constitution into the sixth legislature for your consideration. I can bring you up to speed some of the key steps that we are taking since it was rejected here. We soon after the constitution was rejected, we realized one thing, whether you call it a mistake, but we realized that something that we omitted. As a country, and I'm not blaming anybody for that, but I think as a country we focus too much on the product. That's the document we wanted, and did not pay much attention to the process of how you get that document approved. That is the political process. All the consultations that were being done is subjected to basically questionnaires that were prepared as what do you want? Do you want time limit or not? Do you want it? So we focus more on the content of developing the document. But I think we did not give equal attention to the fact that it's a political document and it has to go through a political process to get it done. And we failed in the process. Product, we got a good product, but we couldn't get it through the political process. And I think we've learned very quickly from that immediately it was rejected. And that was why we launched the political dialogue around the draft constitution. And you were aware, you must have been following, that we had a series of bringing political leaders together with the intervention of, I think, Goodluck Jonathan, that I was inviting into the country, which culminated into taking all the political leaders to Abuja and look at this document. So, because the thing is, in as much as the citizens or different stakeholders have said, we want this and that into the constitution, it is the politicians in the end that will decide whether this constitution will see the light of day or not. And we did not give them the required role in the process. You remember when the draft came out, it was submitted to executive. There was a big campaign, don't touch our draft constitution. So there are some believe that the executive have no right to change even a letter. When it came to the National Assembly, the same campaign, don't touch our draft. But in the end, we now lost the baby and the bathwater. So could we have allowed the executive in hindsight? Could we have allowed the National Assembly to edit one or two small things, but yet we have a constitution, than telling them that don't change anything, pass it as it is? And it's like some of them said, look, if we are not going to change anything, then we are not going to support it. Because there are things there that we don't like. So now we brought these political parties together. And in the process, we've learned a lot, especially being the ministry in charge of this document. I've realized that there are some political parties themselves who don't like certain things in the constitution. And that came out during the consultation. So during the consultation, the political parties that presumably were in support of the draft started saying, that thing we don't like it, that thing we don't like it, and then they were able to come together and adjust it. So we have got it adjusted, but we have to take an informed position, whether it's going to come in that format or whether it has to again be subjected to another popular debate and consultation. We will take an informed position about it. But to answer your question, clearly, yes, government is committed in bringing the draft constitution. And I hope sooner than later you will have the opportunity during your tenure to have the opportunity of debating that constitution once again.
Thank you.
Thank you.
Honorable Minister, thank you very much for answering all the questions so explicitly. But still, I don't want to ask anything about the draft constitution, but now the country raised and your reaction to what country raised. For me, I don't think we can have a constitution where everybody agreed, the political parties, the opposition, the ruling. This is never going to be possible, Honorable Minister. You will never achieve that kind of constitution. So it's going to be a constitution. It is a progressive law. It's going to affect one person or the other, but let us just make sure it is a progressive law and we move on with it. If you want to satisfy everybody, it's not going to work. Now, I'm going to roll you back to what I said about Mr. Manga and Sonko. Manga, you say, should be reprimanded, but Mr. Sonko should be banned, right? And this was a TRRC recommendation approved by the executive. For me, executive, I don't think has any mandate or any power again to review new evidence. Do you understand? I think Mr. Sonko is banned, so go to the appeal court. Not you guys accepting further evidence to see whether he can be acquitted or not. He's recommended by the TRRC, which is act, and approved by you guys at the executive. Now it's over. If he has anything, he should go to the appeal court. I don't think you guys should receive.
Probably that's where the misconception is. I need to clear for you. It is part of the acceptance. It is in the acceptance that government accepted and said we are accepting on condition that we will refer it for further investigation. So it's not accepted holistically.
I still see that you guys want to create a way for Sonko to go.
No, I agree.
No, this is not about no, it's not about. Look, anyway, you are entitled to your opinion.
Yeah.
Because sometimes,
I think in respect to the former IGP or former Interior Minister's case, I believe the white paper, if I'm not mistaken, did exonerate him and that of so. These are the two people that were exonerated.
No. Sonko was not exonerated at all. What we said is, if you go to the white paper about Sonko, you will see clearly, and it's expressly stated, we say in light of new evidence, the matter will be subjected to a second. We will refer it for an investigation. So we did not reject it, we did not accept it outright, but we don't want to also ignore it because these are implicating evidence as far as the TRRC is concerned. We recognize the fact that it's not for cabinet or government to say, no, TRRC, you are wrong, Sonko is right. Or Sonko, you are wrong, TRRC is right. But in light of what we saw, remember, we are not doing it in a vacuum. We have received something that we cannot make public, but it will be available to that body. And you as National Assembly can summon that body to come and tell you, for example, whichever way they concluded. We are very transparent about it. We are not hiding anything. But in light of what we saw, sometimes it's very difficult to close your eyes to certain plain things that you see.
Very well. Honestly.
Yeah.
Okay. So, in the absence of any new thing, Honourable Minister, we thank you very much for honoring the invitation, but we are just assuring you this is just the beginning. This committee would soon roll out its activities, but we felt it necessary to interact with ministers that are under the human rights and constitutional matters before we roll out our activities. But we already have our planned activities that we soon roll out. So we would have more interactions with you and your ministry sooner or later.
Thank you.
Thank you very much.
I don't know whether it will be on record or off record. I wanted to say something, but I don't know.
The choice is yours. You want it off record, it can be off record.
That is between us and the committee. You can keep that off record.
Off record.
I just wanted